Welcome. This is a course about the strange world of government contracting, a world where the customer can audit, investigate, and put the seller in jail. How do we know this? Well, we are three lawyers from Miles and Stockbridge, a law firm of over 240 lawyers, and we have the combined experience of over 90 years of representing government contractors of all sizes, from startups to the world's largest corporations. And we focus on not only representing those contractors in responding to audits and investigations, but proactively preparing our clients to survive and thrive in the world of this unusual environment where the customer can put you in jail.
Yeah, the False Claims Act is worth talking about at some length because it looms over so many contractor interactions with the government, and it's so powerful. Agency audits can have repercussions beyond cost disallowances or price reductions. The government can initiate investigations and ultimately file not only civil actions but criminal actions against a contractor based on audit findings. And in particular, the government auditor and investigators can turn their findings over to the Department of Justice for a potential action under the Civil False Claims Act, or the FCA. And as I mentioned previously, the FCA is the government's weapon of choice and by far the most powerful weapon to address alleged fraud involving public funds. In addition, private parties, individuals, can institute FCA actions on behalf of the government. Stepping back from these aspects of the False Claims Act, you have to realize how extraordinary it is that one of your customers, completely unlike any of your commercial customers, can institute these civil and criminal actions against you based on a contractual relationship, and that private parties, individuals, can institute these actions against you as well. It's very extraordinary. And for the private party suits against contractors, there are a large number of those suits.
And the individuals that bring them can be your own employees.
Former employees, your own employees, and like I said, there's a large number of those actions, which are known as qui tam actions, and we'll discuss those a little later.
So to underscore the impact of the civil penalty for each false claim, what is a claim when you're dealing with a contractual relationship?
Well, claim has been defined by recent legislation to the government. As I said, the primary provision in the False Claims Act talks about the submission of a false or fraudulent claim for payment or approval. It no longer says to the government. The recent legislative change changed that and defined the term claim to basically involve a claim for funds that are provided by the United States government. So they can be, again, subcontractor claims to primes, claims submitted under U.S. grants and loans. It's a very broad set of circumstances.
And they add up because it's invoice by invoice?
They can add up substantially over many months, if not years. So between the penalties for each false claim and the treble damages, you can see that the Act packs a substantial financial wallop. Also, the amounts for penalties are adjusted each year for inflation.
And they're going up.
They always go up. Turning to the types of False Claims Act, as I said, the Department of Justice can bring a civil action against a violator of the FCA by its own accord. The False Claims Act has a criminal counterpart that provides a 5-year prison term for violations. And as I mentioned, a private person known as a relator can file an FCA civil suit on behalf of the government that is known as a qui tam action. Once the suit's filed, it remains under seal for at least 60 days, during which DOJ will investigate the matter and decide whether it will intervene in the case.
Isn't the reality that it's much longer than 60 days?
Well, I was going to say, the government usually asks for several extensions and gets them before it makes its intervention decision. And during that time, because it's under seal, the defendant has no knowledge of the case.
So it's pretty frustrating for the
Frustrating, and it's very strange, a very unusual aspect of federal law.
Okay, so you've seen now that audits can lead to False Claims Act in proceedings, but they can also lead to investigations, or investigations can just start on their own. But with investigations, there's a little bit of a difference. You may not even know that an investigation has started. People can be investigating you by knocking on the screen door of one of your employees, and you may not hear about that. So we're going to dive now into how do you respond first to that audit and then to the investigation, and compare a little bit of the difference between an audit and an investigation. And now we're going to turn for some words of wisdom to the one person on this panel who's actually been on the front lines and in-house counsel for a large defense contractor.
The basic rule in regard to the role of counsel is that no audit is too routine for the involvement of counsel. The counsel doesn't have to go in and perform, doesn't have to interface with the government, but the counsel should know that the audit is going on and be able to handle issues, most importantly, scope. These rise at the beginning of the audit, and if documents produced that shouldn't be produced, you can't get them back. The second rule is, if there are any adverse findings by the auditors at any stage, counsel should be involved in preparing the contractor's response. What you don't want is a situation where early answers, when reviewed later, the contractor will go, that didn't make sense, particularly when if you get to litigation, where there are contradictory answers that were given at the beginning. And finally, if there is a final decision by the government asserting a claim on the basis of an audit, counsel has to take the lead role. It becomes litigation at this point, and the counsel has to be involved in the decision-making and document preparation.
It's better to be prepared in advance. Know what you're going to do if and when a search warrant occurs. And I've gotten calls from in-house counsel, not Ted, but other in-house counsel saying, oh my God, people have shown up, they've got their rain jackets on with 3 letters on the back, and they want to take my files. What do I do? And the first thing to tell them is stay out of the way of the guns, but then keep records of what they're looking for and what they may be taking out. Develop some sort of rapport with the agent. Take a look at the search warrant. Object to the seizure of privileged documents, but don't obstruct the search warrant. Try to keep a record of everything. Don't prevent them from doing what they're doing, and be careful that you're not creating a crime by obstructing what they're doing. But it is a dangerous situation. It is the nuclear option. And it is important to be prepared for that. So we have, in fact, created sort of a cheat sheet for folks, a one-pager that local in-house counsel can have that says, this is what I do when a search warrant. It's like having the fire extinguisher on the wall. If the contractor receives a demand for interviews of its employees, the contractor can ask that counsel should be present at the interview. And it should make that request. Ted, what do you do?
I agree. I mean, the employee can say no. However, it's best for a counsel to be there to be able to monitor the situation for the company, his employee.
You want to get out in front because you can be suspended and debarred for a violation of criminal law, violation of Civil False Claims Act, or any significant overpayments. So those are the kinds of things that you want to be on the watchword for. And Cameron, have you had experience doing a mandatory disclosure?
I have, and it's a very difficult thing to do, but you ultimately need counsel involved, and you need to make the right decision. And you need to make a record of the reasons why you make that decision, and it's the responsible thing to do. You have to do it under your clause. It may be painful, but the consequences of not doing it and having it later found out are much more severe.
And severe means no longer being able to be a government contractor in
Right.
certain instances.
The death penalty, suspension and debarment.
Let me wrap up with 3 important points. And that is, throughout this we've talked about the rules. They're complicated, They start out with statutes, regulations, the FAR, Federal Acquisition Regulations, the supplements to the FAR. You need to know those rules to play in this fairly unique world that's very unlike the commercial sector. So that's point one. Do your homework, know the rules. The second is you have to know the reality, and that the government is the only customer that can come after you with the Civil False Claims Act, the Criminal False Claims Act, can investigate you, and can ultimately put you in jail and put you out of business through suspension and debarment. And the third is you need to understand that the best defense perhaps is a good offense, but more by a good offense is a good infrastructure that allows you to withstand the storm of a government audit and investigation and prepares you for that.